Hi, it's Mike DelSignore, and in this video, I'm going to tell you everything you need to understand what a continuance without a finding is on a first offense OUI. So many people who are charged with an OUI have heard that term. When you go to court, you'll see other people taking a plea of a CWOF, and you'll wonder, what is it? Is it a good deal for your case? Well, my name is Michael DelSignore, and I've been handling OUI cases in Massachusetts for my entire career. And I'm going to explain to you what it means, what a CWOF is and what it isn't, because some people have a misconception when they hear the term and when they hear it described in court. So continuance without a finding is technically not a conviction, but it is an admission to sufficient facts. So on an OUI offense, a continuance without a finding would mean that you admitted to the OUI offense. Your license would be suspended for 45 days. You'll be placed on probation for a year, and you'll have to pay certain fines and fees. And those fines and fees will be about $13.80 to the court. The 24D alcohol education program will run you $867, and you'll have to pay $500 to the registry. If you refused a breath test, $500 if you took a breath test and was over 0.08, and then another $500 based on the conviction for OUI. So a CWOF is an admission to sufficient facts, meaning that technically it's not a conviction. So why is that important? So if, let's say you work as a electrician, or you work at a department store, these employers will have sort of the lowest level of access to CORI records, and they shouldn't see a continuance without a finding because it's technically not a conviction. However, if you're a teacher, you work in a hospital or a bank, they're going to have a greater access to CORI records, so they'll be able to see a CWOF even though it's technically not a conviction. So while a CWOF isn't technically a conviction, many employers will still see a CWOF, and it still counts as an OUI as far as the registry is concerned. So if you ever got suspended again, it would count as a second offense. And many states will also treat a CWOF as a conviction. So the benefit of the CWOF is it's technically not a conviction if you have a license to carry. A CWOF will allow you to continue to have a license to carry, where if you got a guilty, you'd be forever barred to have a license to carry. So it can have some limited benefits, but for the most part, a CWOF and a guilty are pretty much the same thing. So for many people, the best decision in an OUI case is to take the case to trial. In Massachusetts, our judges typically don't penalize someone for going to trial. That's not true in other states. In other states, judges will impose a harsher sentence after trial than before trial. But for the most part, judges in Massachusetts they'll find you, if you're found guilty, you'll have a guilty entry on your record, but you'll still have the same license loss, fines and fees, and the same probationary period. So there's not, for many people, there's not a huge risk of taking a case to trial. Now, there are some benefits when you take a plea. The legal fee obviously would be less, but some of the other charges would get dismissed. So if you're charged with negligent operation, if you're charged with leaving the scene, a lot of times you can negotiate a dismissal of those charges in exchange for a plea on the OUI. Not all the time, but you have more bargaining power before trial versus after trial. So that's one benefit of taking a plea. Sometimes if you take a case to trial and you're fighting both the OUI and the negligent operation charge, the strategy I use, and it's successful many times, is we'll have the jury hook you on the negligent operation and find you not guilty on the OUI. Now that split verdict, while that happens often, sometimes a jury may come back and find you guilty on both charges. In that case, you'd have a 45-day license loss and a 60-day license loss for the guilty on the negligent operation. There's ways to get a hardship and get back on the road, but it's a little more encumbrance on your license. Now, negligent operation is different. So continuance without a finding is a term that applies to every criminal charge, not just OUIs. So for some charges like negligent operation, a continuance without a finding, meaning it's technically not a conviction, that saves you the license loss. So the registry doesn't suspend someone's license on a CWOF for a negligent operation because it's not a conviction. Now for OUIs, they treat the CWOF as a conviction. If you're not a citizen, a CWOF is as good as a conviction. So as far as the OUI charge goes, there isn't a major difference between a CWOF and a guilty. Now, some people, I think, get confused because they hear the court say, if after a year you don't violate probation, the charge is dismissed. And I think people misinterpret that as meaning dismissed didn't happen. It's dismissed meaning the case is closed off with the court. So what about your record? So let's say you take a CWOF on an OUI. When can you seal that? You technically can seal a CWOF prior to 3 years, but I think most judges are probably going to make you wait at least 2 years. Whereas a guilty, you would have to wait 3 years to seal. So it gives you a little more ability to seal a case quicker, but I would say it's not dramatic. You'll still be able to seal the case guilty after 3 years. So when you hear that term used in court, I think it's important to understand that it's not a dismissal. It doesn't mean you won the case. And the CWOF is not going away. So you hear this term on the first court date, you wonder, should you take it? There's no rush to accept a CWOF. You can accept, they'll give you a CWOF on an OUI right up until trial. Until the trial starts, that CWOF is really always on the table. So let's say you made some statements that were incriminating, that the government is going to try to use against you. You could do a motion to suppress, try to get those statements excluded from evidence. If you're successful, then you have a better case for trial. If you're not successful, you can still accept a CWOF. If there's a breath test in the case, you can try to get the breath test and fight it at every stage of the process. You can do a motion in limine to exclude the test. You can also try to get the test excluded on the trial date. If all those efforts are unsuccessful, you can submit a plea of a CWOF right before the trial. So there's no rush to take a CWOF. You can sort of fight the case as much as you can. In some cases, there might be legal issues that you want to litigate and you want to fight. You can do that, so you don't have to rush into accepting a continuance without a finding. There is a little bit of a benefit. Let's say you do take a CWOF quickly. Let's say you took a breath test. It was over 0.08. If you take a CWOF, say, within the 30 days. So let's say your original arraignment was June 1st. The court might give you a date of July 20th for pretrial hearing. You hire an attorney. Let's say you hired me for the case and you told me you wanted to get back on the road quickly. We determined that this was a case that you should resolve. We can bring that case forward, have you plea out, within a day or two or a week of your arraignment. So then your license loss for the 30 days ends and your 45 days start. So you'd save a little bit of time. By resolving the case within the 30 days, you end that 30-day suspension, you start the 45 days. So just to be abundantly clear, if you plea out to an OUI on day 29, you save a day. If you plea out on the first day, you save the full 30 days and you start the 45 days. Once your 30-day suspension ends, then there'd be a new 45-day suspension. So you don't get credit for any of the 30 days for the breath test failure suspension towards the suspension for a DUI conviction, which a CWOF is considered a conviction by the registry in terms of the 45-day suspension. The other scenarios, if you resolve an OUI case, if you refuse a breath test, you receive a CWOF, even if you were found guilty, you're eligible for a hardship license. But a plea would allow you to get a hardship license quicker. If you go to trial in a first OUI, within the 6 months you found guilty, you're still eligible for a hardship license, still can get back on the road. So understand that, number one, a CWOF isn't a dismissal. Number two, there's no rush to accept a CWOF. You should make sure you understand the case, understand the strengths, the weaknesses of the case, get all the evidence, get any videotape evidence. There's many police departments have video evidence, and most people look good on the video, so it would typically help you in your case. If you have questions on what it means to accept a continuance without a finding, feel free to call me. My name is Michael DelSignore. I help people every day charged with OUI. It's my passion to help people put OUI cases behind them, to help them move forward with their lives, and I do that by being ready for trial, preparing for trial every day. That's my passion, and I hope to help you with your case. And you can call, text. It's never too early, too late to call, 781-686-5924.